Hey everyone, thanks for showing up to Addie Prewitt Live today. I'm Addie Prewitt, a New Orleans-based estate planning attorney. I'm a mother of two small boys, and my husband and I own a couple of independent pharmacies in the New Orleans area. So we have a lot going on. I'm so glad y'all could make it today. But today's topic and what I wanted to start with was back to basics. Do I need a will? So I guess the first thing to talk about is sort of what a will is. It's pretty simply can be boiled down to a couple things. It's a legally binding document that says where you want your property to go when you die and who you want to be in charge of that process. We typically refer to that person as the executor. So two things, where you want the property to go and who gets to be in charge of that process. So I think the easiest way to think about who needs a will or whether you need a will is what happens if you don't have a will. If you don't have a will, the state decides where your property goes. Every state, including Louisiana, has the laws of intestacy, and they say, in the event you die without a will, here's how your property goes. First to this person, then to that person, then to this person. So if you don't want that to happen, you have to have a will. It's that simple. Otherwise, it goes according to the laws of intestacy. A couple people I will say who should definitely have a will if you are married, especially in Louisiana, especially if you had stuff before you were married. So Louisiana is a community property state. Whether your property is community or separate determines where it goes under the laws of intestacy. So if you're married, you need a will. If you have children, especially if they are under the age of 18, they are minors. A will is a primary way that people will designate who can be a guardian of their children if something should happen to both of the parents. Guardian, and Louisiana, it's called a tutor. So if you're doing a Louisiana will, you may not even see the word guardian. It's referred to as a tutor, but that's the way you can say, I want my sister or I want my brother to raise these children if something happens to me. Third question that we kind of want to talk about, let's say you are married, you have children, and you had property before you were married, such as me and my spouse each had a house when we met. In that case, you definitely want to have a will. The laws of intestacy, whether it's separate property or community property, might leave the house to your children rather than to your spouse, which is probably not how most people want that to happen. So it's really important to have a will in those circumstances. The next thing I think is helpful to think about is, what do you have? How much property do you have? So let's say you're single, you have a bank account, you have a house, you have a car. You'll definitely want a will in those circumstances. You don't want the state to decide. I see a lot of people say net worth of over $100,000. But really, having dealt with banks, I think, even having a bank account is sufficiently enough to trigger whether or not you should have a will, because when someone goes to sort of get those proceeds and distribute it out, the banks will make you hop through all of the hoops to do that. So if you have a will and someone appointed as executor in there, it makes it a heck of a lot easier to get that done. Now, are there any times where having a will doesn't really help? There actually are. There are some assets that don't go through your will. The primary ones that we see are life insurance and retirement benefits. Those will always pass according to your beneficiary designation. So whether you say in your will, I want my proceeds of my life insurance to go to X, that's not really going to control it. That beneficiary designation is really going to control. And a lot of times you'll hear people like me or even financial planners say, make sure you review those, make sure you to update those. But it's really important, particularly if you have live video there, my husband calling in. Particularly if you have big life circumstances, such as you got married, you're getting divorced, you had children, starting a new job, retiring. Those are all, really good reasons to take a look at that and make sure it's the way you want it to go. So actually in the Instagram feed, we had a couple of questions come in, which was awesome. So if you ever are in that circumstance and have some questions, let us know. The first question, where do I practice? I practice in Louisiana. I am barred and licensed here, went to law school here. I have worked in New York City and Atlanta as a tax consultant. So I didn't have to be barred in those states, but I am actually barred in Texas, although I've never practiced there. So that's a little bit about me. The next question we had is, what's the right age to create a will? And that's a great question. So anyone over the age of 18 has the legal capacity to create a will, especially in Louisiana. I don't know about other states, but this is Louisiana we're talking about. An 18-year-old may not have many assets, so you don't typically see them creating a will. But, some of the other things that we talked about before, such as, having a bank account, buying a car, having a house. Even young people can have those types of assets, and it's very important that, if they're doing that sort of process, they should definitely think about it. I would say, definitely by your 30s, be thinking about it. Be thinking about where you might want your property to go if something happened to you. So those are all the questions that came in today. I hope you enjoyed the video. Be sure to like, follow, subscribe, do all the stuff on the social media networks. You can find out any more information about me or catch up on any other videos at addieprewittlaw.com. And that's all I have for you today. Thanks for watching. Hope you guys have a great day. Bye.